This podcast is not intended as legal advice. If you're in need of legal services, please contact 602-375-6752 to set up a consultation. You're listening to the official podcast of the Law Office of Libby Banks, Estate Planning, Wills, and Trusts. Hosted by Libby Banks and Travis Meyers, your estate planning attorneys in the Phoenix Valley.
All right. Well, we are the Law Office of Libby Banks, and this is our podcast.
Yes, welcome.
I'm Libby Banks.
And I'm Travis Meyers.
And I welcome you all here. Today we thought we'd talk a little bit about trusts. And one of the things that we often hear is, oh, I've just got a small estate. I don't need a trust. Do you hear that too, Travis?
All the time.
And tell me what you talk about when you hear that.
You know, I hear from a lot of people that trust just triggers this mentality of something like Scrooge McDuck diving into a big pile of gold in his money cavern. It's not that way. It's a tool. It's an effective tool that can be used and can be as simple as you want it to be. I
hear too, the trust fund babies. I think that's sometimes what people think as well. They think of, I'm not rich. I've never been a trust fund baby. I haven't developed that kind of wealth. My kids aren't going to be inheriting something enormous. And so then why are you talking to me about trusts?
Right. Yeah, it's something that people misconstrue as something only for the rich and famous. And the fact of the matter is a trust can be as simple or as complicated as you want it to be. And that fits what you're hoping to achieve in transferring any of your assets to people during incapacity or passing away.
Exactly. My stepfather he's retired now, an estate planning attorney, among other things. He was kind of a jack of all trades. But when he talked about the trusts, he had a little shopping cart, and it had a little tiny stock certificate and a little tiny house, and he would show that. And it's like, this is just the way you manage your stuff. So the trust is kind of like the shopping cart for your assets. You put things in, you can take things out, and you're in control during your lifetime. You're pushing the cart. But if you're incapacitated, you can't handle your finances anymore, somebody else can push the cart for you. And when you're gone, somebody else is emptying the cart and giving the assets to the people that you want. And I love that analogy.
Mm-hmm. Yeah, another metaphor that I hear all the time in this area of the law is you're taking your family on a beach vacation, and you have a car that you put all of the things like the umbrella, the picnic basket, the sunscreen, all the things that you would need for the beach. And you know that you feel good about all the work that you've taken to put all of those things into the car, and that you're going to have a good time at the beach with your family. And if for some reason you need to take a nap, or if you're incapacitated, so to speak, someone else can jump into the driver's seat of that car, your successor trustee, and drive the car to the beach, and you and your family will have the best time and peace of mind possible, knowing that you've prepared well for the end of your life, or incapacity for your trust, or for your beach vacation, for that particular metaphor.
Yep. I like that one too. That's a good one. So thinking about how the trust works, and because people, even using those metaphors, analogies, examples of things we do in everyday life that could be similar to what we do with our trust, people still don't understand exactly what it is the trust does. So I usually start with, the trust is a document, just like the will is. Your will has your wishes for your end of life. So does the trust. The trust has those distributions. Who's going to get your stuff when you're gone? How is it going to be handled? Who's going to be in charge? Just the same as a will. But then it does more. We've kind of alluded to the incapacity, so I'll let you speak to that aspect.
Yes. The trust not only handles things after you've passed away, but also names people to step into your shoes, called trustees, or in particular, incapacity trustees, that have near immediate access to all of the assets should something happen to you. Should a doctor say that you can't handle your finances because of a condition that you have, or even if you've been missing for 30 days, or however the trust defines it is what it ends up being, but it gives a lot more tools and latitude to the people you've named to take care of your things, to step in and make sure you're not missing bills, that you're not missing mortgage payments, that the assets that you've taken careful care to accumulate and protect over your lifetime are not lost because of some unfortunate thing that happens while you're out of commission.
And the other thing is not just that they're lost, but that the people who you would expect would step in to try to keep things running don't have to go to court. So that's an awesome thing about the trust too, and something that in our trusts, we really build a lot in to avoiding any court proceedings wherever possible. So if somebody's incapacitated and they don't have a trust and they don't have a power of attorney, they have nothing in place, their child or even a spouse can't step in to deal with their separate assets. So they can go to the bank all day long and the bank is going to say, sorry, that's their account. You go to the stockbroker, sorry, it's their account. Try to sell the house or make the payment. Sorry, you're not on the loan. You're not on the title. And so the trust really avoids that next step that they would have to take, which is to file a court conservatorship where they ask the court to be appointed. Requires at least 2 attorneys, very cumbersome proceeding. And of course, like all court that involves attorneys, is really expensive. And it can take a while before you actually get what you need to help the person who's incapacitated.
Absolutely. And not only that, there are certain conservatorship situations that can kind of be humiliating. Right? It's
yes.
A situation where, we've seen it so many times where one spouse may be in perfect health and the other spouse may be in the beginning stages or even in some advanced stages of Alzheimer's or dementia or something like that, where they really can't handle their own assets. But if they don't have some sort of tool or it's something giving authority to the people they want to be handling their things, they're having to go through this long court battle with someone that they've been married to for decades.
Right.
And it causes a lot more grief than it's worth.
Yeah. It's easy to prevent that type of proceeding. And that's a public proceeding. So I've gone to court just to get my little probate order signed by the judge. And in waiting for my turn to appear, sat through some of those, some of which were very humiliating for the people who were, not ready to accept that they were incapacitated and also didn't have the proper documentation that would have allowed the family to help them out without having to go to court. So it's that's a big thing that people, I think, appreciate as well, is the privacy. So you're our probate attorney here in the office. So talk about the difference between the public nature of probate versus the private handling of trusts.
Absolutely. So as you had pointed out before, you had been an attorney who went to court quite often and were just sitting there waiting your turn and got to listen to these very public hearings that anyone could attend if they wanted to, that go into some pretty decent details of what is going on in people's lives. Now, in contested probate situations, those hearings are public. They're available to anyone who wants to sit in on them. And not only are they just available to any passerby, all the information and pleadings, all the paperwork that is involved with it is available for search on the court website in a probate.
Yeah, I really shocked a client one day when they talked about their mother's probate plan or a case, and I called, it was Andy was my administrative assistant, my husband at the time, and I called him in and I said, go and get this document from the court. And she was in shock. She had no idea that all of that was still public record and that anybody could walk into the court and get copies of that.
Yeah.
So people don't realize how public that is.
Mm-hmm. And that can be a real issue for some people. For family members that you might not get along with, if they catch wind that someone has passed away, they can do a pretty basic search. It's not hard to find those materials to come in and do what they will with that information. Sometimes it's not a big deal. Sometimes it's a very big deal if there are family fights or family strife going on for those particular probate cases. In addition, I know I touched on this in a previous episode, but it's not only just open to family members, but it's open to any professional that may benefit from contacting a personal representative. We've seen it in the past where, again, I will give the disclaimer that I don't believe that all real estate investors are bad. It is a very legitimate way of doing business and making a living. But I have seen some real estate investors reach out early in the process to personal representatives, someone who is going through a very grieving moment in their life, who maybe wants to take care of everything that they can as expeditiously as possible. And a real estate investor reaches out to this person, gives them a very basic, maybe even a lowball offer on the family home, which I've seen accepted. And it's caused problems for the personal representative in the probate because they have a legal duty. They have what's called a fiduciary duty to get everything that they can for the beneficiaries involved. And that means, selling the house for as much money as you can get for it. It puts them in danger of being sued by the beneficiaries if they don't follow their fiduciary duty and get everything that they can. So whether it's a real estate investor or a angry family member, by virtue of it being public, it really can cause problems for families if we're going through that probate process.
Right. And, within the trust, the trustee also has that same fiduciary duty, but they don't get bombarded with those calls, with letters, with people trying to, entice them to, here's the easy way to get that house sold. You don't have to go through this whole real estate deal. I can help you out and make this easy. It's just easier not to have to deal with those people, not to have to say no, not to pick up the phone only to find that somebody's calling you once again to bother you about something in the probate. So it can be a mess. And for people who are leaving out beneficiaries that might otherwise expect to be included, that public nature can be really huge. One, it's the public, they may be able to search and see that a probate's been filed. They could try to pile in on that, file something, just make problems, even if there's no particular right. And the other thing is, if we're disinheriting children, we still have to give them notice. So we have to notify legal heirs. And so somebody who's got a child that they're estranged from that they want to leave out, the will, if we probate it, that we still have to give them notice. And the worst is when we don't know where they are. Now we're trying to find them. We're doing a publication notice. So, now it's in the paper that we're looking for this child and notifying this child. So the trust just really does provide that privacy that so many people, I think that's important to them to maintain privacy. It doesn't necessarily keep, a home title private. I know we have some clients who name their trust something unusual that's not their name. Somebody who's savvy enough can look up to see who the trustees of that are, who the beneficiaries are, and know that you, Travis, and your wife have a trust, and that the two of you are the current beneficiaries. But that makes me think also, one of the other questions that I get a lot is, well, wait a minute, I don't want to lose control of my assets. I don't want to share my assets with my kids yet. I need it for me. So when I'm sure you get those same questions. So why don't you speak to that a little bit?
Absolutely. The real benefit of having what's called a revocable living trust, which is the type of trust that we make for most of our clients, is that you get to still be in the driver's seat handling your assets throughout your lifetime. There's really not much that changes in the way of your day-to-day use of your assets. What you're doing is you're changing the way that you own the assets. You change them from owning them just as yourself to owning them as trustee of your trust, so that makes the trust effective. In the metaphor, that puts the groceries in the cart, that puts the beach equipment in the car. That's how the trust becomes effective. And during your lifetime, you use everything the same way as you normally would. In fact, at most bank accounts, if you put them into the trust, most banks, not all banks, but most of them, don't even make you change your bank account number. It really is just using it the same way as you were before. But the difference is that if something happens to you, the person that is named in your document to step into your shoes has basically ready access to that if it needs to happen.
Right. And you're still the beneficiary. So
Yes.
As the owner of the trust, it's still your property. They have a duty, the fiduciary duty, to spend the assets on your behalf while you're still here, and the duty to follow your instructions when you pass away. So definitely that same situation. And another question I get is will I have to file a tax return for the trust as well as for myself? But again, this type of trust, I always say the IRS ignores it. So it's called a grantor trust, and you report your income the exact same way before you put things in the trust as after you put things in the trust. So again, a very easy way to manage your assets during your lifetime, avoid court proceedings all along the way during incapacity or on your passing, and minimize attorney's fees and heartache and problems for your family.
Absolutely. And one other thing that I know to be a tremendous benefit of a revocable living trust is it's not a one and done, set and forget type of thing. It's something that you create at certain moments in your life. We have a lot of clients that come in who are young families who have concerns about wanting to make sure that their young children are taken care of. So we create a plan for them. We help them name guardians. We put trust in place to make sure that their kids are protected. we see a lot of times those same clients coming back to us as their children grow up. Maybe the same people that they wanted handling their finances or making healthcare decisions are not the same people that they wanted 5 years ago when they created the trust in the first place. It is incredibly easy to update and make changes to revocable living trusts, which is another added benefit of this type of planning.
Absolutely, yeah. And I'm seeing clients come in and now they're naming their children that they named guardians for in their trust, now are old enough to serve as the trustees of the trust and the responsible financial people that they are going to call on when they need that help. So that's really great. So thinking about what things that we build into our trust, because I really do feel like we're belt and suspenders attorneys. We build in a lot of things, as we've said, to avoid court proceedings. But some of the other things we build in are beneficial for the people who are inheriting from us. One of them is what we call a standby special needs trust or standby supplemental needs trust. And having worked in the Social Security income area before you came to work with us, you're familiar with some of the rules that if somebody's receiving some government benefits, an inheritance can really disrupt those benefits. So do you want to talk about that a little bit?
Sure, absolutely. So from what I know about Social Security disability in particular, there are multiple types of benefits that can come from applying for disability. The idea behind those benefits is that people who cannot work or have some sort of impairment that keeps them from working more than a year can get assistance from the government so that they're not left out on their own on the street. In addition to that, they also get health care from the government as well. Depending on what type of benefit you get, you might get Medicare from that early. You might also, depending on the benefit, get Medicaid as well, which is essential for helping to control the costs of that population. Because if you have something that's keeping you from being able to work or do anything for a year, you're at the doctor all the time. And so having those types of benefits in place is essential for those people. But for certain types of benefits, in particular, supplemental security income, or what's called SSI at the federal level, or I know there are state benefits as well. They have strict income requirements.
And so just thinking about an example of somebody who might need those benefits would be, potentially a 16-year-old who ends up with a head injury. They've never worked, so they're not entitled to the type of Social Security that someone who's worked all their lives have built up a right to get some Social Security disability benefits if they're actually disabled. Somebody who's never worked, an autistic person, again, somebody who's got a brain injury and now cannot ever work, they rely on SSI potentially. And it's not just the money, but also services sometimes. So sometimes there's psychological care, sometimes there's particular doctors, or they're in a facility that is really supporting them well in terms of living a really good life as far as that can happen, given what's happened to them. And the inheritance that they could get would kick them out of that place that is really serving them well, could kick them off of the services they're getting, not just the potential income. There's so much more potential there. And sometimes we don't know that that person is going to be inheriting from us. It could be a grandchild that is fine now. It could be the unborn grandchild that is born with autism to such a degree that they'll never be able to work. So that standby trust then lets us hold that child's distribution in a trust that doesn't disrupt what they have in place if we don't want it to disrupt their situation. So that's always part of our trusts as a backup support for that occasional situation that can come up with somebody who's inheriting in that situation.
Yeah, and one more reason why that type of thing is so important is because not only does it protect them from being kicked off in the first place, but let's say they were kicked off. I worked with this population for a couple of years and learned one thing in particular, and that it takes so long to get back on those benefits.
Right.
So if for some reason we didn't have those and they got this inheritance, a lot of money would be spent on those healthcare costs, on maybe trying to keep them in that facility with the money that they got. That money would run out almost within a very short amount of time. And then we'd be stuck probably spending a multiple year process trying to get back on those benefits so that they can start and keep on the path that they were before. So, like you said, as a contingency, as in all of our trusts, we have these things there so that it can protect not only what they're receiving inheritance-wise, but make sure that they're not going to have to go through a huge bureaucratic headache to get back on the benefits that they were on in the first place.
Exactly. Then another thing that we offer our clients that I think is great is a trust for their beneficiaries that's built into their revocable trust. So now the revocable trust that we create, that's not an asset protection trust. That's another myth that we see. But it's still your money, just like it's still your stuff in your shopping cart. The law recognizes it's still your money. It's still your home. So there's no creditor protection or asset protection built in there. But instead of giving to children outright, so, the trustee just writes each of them a check and hands it over at the end, we can direct the trustee to set up trusts for each of the children that do provide for them some asset protection and also some divorce protection. In most states, it's considered separate property. Again, we have a lot of ways for parents to plan for their children. We certainly want a minor. We've got to hold those funds in trust with somebody else handling them, or we end up in court again for a conservatorship for the child. So the trust does that, but we can allow the trustee to turn over that trust to an adult child who can manage that property. It's an asset-protected trust, and it's separate property in most states, too.
Yeah, and I think that's very powerful for a lot of our clients because it allows them to continue their legacy for their kids.
Exactly. And so they also can plan for who inherits that trust when their child passes. So even if the child has gotten that trust, stepped in as trustee, if they haven't used all those funds, the parents to direct where does that share go when their child passes. So they can always say it goes to their children. If they're giving to a child who doesn't have children and they want it to go back to the other children or grandchildren, they can direct that. And they can give the child the ability to say in their own will or trust where they want that to go if they want to give them that flexibility as well.
Yes. I think a lot of what our clients really appreciate of the level of contingency planning that we include in our trust is that there is never a question of where it goes to next. If there are holes or we don't know where it goes next, what happens is you run the risk of having everything go to the state or having to involve the court in some way. We include specific provisions that do a lot of contingency planning, almost to an extent of things that may never happen, but that leave no stone unturned, so to speak.
Right, exactly. Yeah, when I did the probate work, we did have one case where we had third cousins that we were having to notify. And so we want to avoid the third cousin. Let's pick a charity. Let's, pick the best friend instead of the third cousin you never met, who might inherit if we're just dealing with, the general, okay, where does it go next? The state says, and it could be third cousins instead. So the trust is really an awesome way to plan, Travis, and I think we've convinced people today.
Couldn't agree more.
Thank you for listening to the official podcast of the Law Office of Libby Banks. If you're in need of an estate plan, please reach out to our team by either calling 602-375-6752 or emailing info@libbybanks.com. You can follow us on Instagram and Facebook. Just search the Law Office of Libby Banks. Free consultations apply to new and existing estate plans only. If an estate plan is not completed or was prepared by a third party, revisions will be given at an hourly rate. This has been a T-Door production. Music by Track Tribe.